You see, this whole argument is premised on whether there's parliamentary supremacy or constitutional supremacy and whatnot.
Is that the issue?
Yes, the whole issue is premised on this. So that some are saying that Parliament are a law unto themselves and whatnot. I think we've moved, as a country, moved away from those positions. You see. Now, let's look at the standing orders of Parliament. All right. Let's look at order. Yes. Let's look at the 2000 version. No, because there are two versions. There's a 2000 version. There's a 2023 version. Now, you will see that the ruling of Speaker Michael Quay is based on the law, the orders as it was. Okay? And for that, it is not 18. It is 18 and 19. Let's look at that. It says, a member who desires to resign his seat in the House shall notify the Speaker in writing and under his hand of his intention to resign his seat, and the Speaker shall inform the House as practicable. 19. The seat of a member shall be declared vacant by Speaker under clause 1b to H of Article 97. So it's not 18, it's 19. Now, in the wisdom of parliamentarians, because they are the ones who make the laws, they are the ones who make their orders, they have now amended this, okay, to the current version. Let's look at the current version. Yes. That is 2023 version, which is what is binding, which I use it now. It says that vacancy other than resignation, 18. Reference Article 97, 1b to E, G and H of the Constitution. The Speaker shall inform, not declare. The Speaker shall inform the House of the occurrence of a vacancy of the seat of a member under clause 1b to E, G and H of Article 97. Why is that so? Let's go to the Constitution itself. If you look at Article 97 of the Constitution, 1992, a member shall vacate his seat. He, the member, shall vacate his seat. Now let's come to the G. If he leaves the party of which he is a member at the time of his election to Parliament to join another party who seeks to remain in Parliament as independent, or if he was elected as a member of Parliament as an independent candidate and joins a political party. Then it comes to 99. Article 99. A high court shall have jurisdiction to hear and determine any question whether, and my brother read it, a party has been validly elected as a member, has been validly elected as a member of Parliament, or the seat of a member has become vacant. So, a person has been validly elected as Speaker and whatnot. A person aggrieved by the determination of a high court under this article may appeal to the Court of Appeal. So, the act of declaring, that declaratory powers, is not with the Speaker. So when the Speaker comes to declare those seats vacant, he has assumed the jurisdiction of the High Court. Clear. Again, it is for this purpose that Parliament itself amended that order to reflect the current position, because the order itself says in accordance with the Constitution. So this is clear. So we can actually go into Speaker Michael Quay's ruling to say whether we agree with it or not. But it in itself is predicated on an order which has been repealed by the current order. So if the Speaker gives any declaration, it is wrong in law. And he has assumed a jurisdiction which he does not have. 2. My brother also said that the Supreme Court, why, if this was supposed to come to the High Court, why the Supreme Court assumed jurisdiction? The Supreme Court, you already know this, as I said, has the sole jurisdiction for constitutional interpretation and enforcement under Article 130. It's clear. Under Article 131 and 2. Clear. So, where did the Supreme Court go wrong? And my brother Energy also seemed to now go to the empaneling of the Supreme Court to even to suggest that because they were the same persons, there was something untoward about that. Until the intervention of my learned senior, then he has now brought it to mean that he means to say that if the Asin North was disenfranchised by representation by their ruling, then why are they saying this in this instance? Now, the Supreme Court has a power to depart from its previous decisions, its previous rulings. Supreme Court has a power. 2, we cannot say that because
in departing, should the Supreme Court give us the reason why they are departing?
Yes, and they must elongate the panel.
And did they do that?
No, because this is just an interim application. We haven't gone into the substance of it. But all the Supreme Court is saying is that,
yes,
based on these reasons, stay your hands. Actually giving them a time to also file, the Speaker should stay his hands, actually giving a time for them to file their response to this.
No.
So why are you saying that?
No. There is no repeat application.
Sorry?
There is no repeat. It's the substantive matter that they want them to respond.
Precisely.
So as we speak, this order stands as a valid order.
So it's great. I'm very glad you are saying that it stands as a valid order.
No, when I say valid order, has it been vacated? No, has it been vacated?
You are saying that it stands as a valid order.
Go back to this. This is the decision of the Apex Court. Look at it.
To abide by.
No, we're not there yet.
Order.
What I wanted to understand from you.
But you've actually short-circuited it and said it stands as a valid order.
What I wanted to find out from you.
If it stands as a valid order, I want Parliament.
Chief, what I wanted to, I'm learning. I'm not a lawyer.
Okay.
You said that the Supreme Court can depart from its earlier decisions.
Precisely.
I know that for a fact.
Yes.
But in departing, must it not state the reasons why, although it held this position, it is departing from that position to this new position?
That position, as I said.
So in this ruling, did you see that?
Wait. Beside the stating that position, all right, it is a substantive matter that they do so. And in that substantive matter, if it's a constitutional matter, it's not even a panel of 5. It's not a panel of 7. To show that they are now departing in a substantive matter.
Are you suggesting that what they have done in this this decision with respect to the injunction, that what they have done is not final?
Of course.
Why?
Because it is an interlocutory, it's an interim measure.
Yes, but they have given a decision on it.
Precisely. But interim means interim. Interim means interim. Because the substantive matter on which it stands will not have to be decided.
Yeah, but in taking a decision on the interim matter, they have departed
from an interim decision in Judicial.
Yes. So why are you saying
interim?
That interim.
Why is the principle not the same?
How can it be the same?
So in this case, if they have decided that the people of Asin,
when you were talking, I kept so quiet.
No, I agree, but I felt that this is just for public.
Let me ask you.
Right, because you, even in setting the panel, you have sought to twist this to suggest something else. And everything you're saying suggests something else. It's not right. We are lawyers before politicians.
No, but the two people are mentioned.
So the things that we use.
Why are you running away?
The
principle. What the principle?
The rudiments of our training suggest that we do things in a certain way.
So Kingsley, I beg you.
Then you add your political.
Kingsley, I beg you, help me.
Yes.
In taking an interim decision in Jesse Kwesi, they have held a certain position.
Yes.
In taking an interim.
That's what?
About the issue of representation.
Yes.
Yes. In taking an interim decision on this particular one, they departed from that position. Shouldn't they have told us, given a reason for the departure?
You see, in the Judicial Kwesi situation, they are saying
that was also an interlocutory.
They are saying that that party himself was not validly elected. In this case, you are saying that the person was validly elected. That's not an issue.
No, what's the issue? What's the issue? It's about
denying the people representation.
But the speaker, I don't know where do you want to join him? Do you want to go and sit here?
Okay,
then stop.
You proceed.
Then stop.
Okay.
You can go and sit there with him. Okay. Or stop. Now, in this matter, the persons are already acting as MPs representing their constituencies.
But the education was also acting as MP.
No.
He was.
No. The very first time he was elected, before he was sworn in, he was injuncted.
But wasn't he sworn into Parliament?
No. So it was at the time that he was going to be sworn in that injunction was granted.
So if
served, so Edgy, go and sit there. In fact, go and sit there.
Just take notes.
You have already talked about an Order 18, which doesn't exist anymore, and built your analysis on that. It doesn't even exist anymore. So let's make progress on this matter. Mm-hmm. At the time of the person being sworn in, there was an injunction placed on him not to be sworn in. Mm-hmm. He said he would assume all responsibility of that.
But was he sworn in?
No. By the time he was served, he wasn't. It was when it was brought to his attention that brought the rancor in Parliament. Then he said he will assume that whatever comes out of it.
No,
so whatever comes out of it is on him.
Chief, the question I'm asking is that at the time the Supreme Court took the decision in the interlocutory matter, had he been sworn in as MP or not?
There was an injunction placed on him to begin with by the High Court.
No. My issue is, at the time the Supreme Court took the decision, had he been sworn in as MP for Asin North?
But I'm saying there's an injunction. I'm saying there's an injunction placed on to begin with. That you shouldn't even be there. It's a different matter altogether. There's an injunction from the High Court. You cannot swear this person in. Parliament had to go through one or two rounds before. In statu populari, he kept to stand there. We all swore together, but you are guided by your own thing. He said that he would assume any responsibility come out of it. We cannot transpose those matters and those facts into this one.
But
where the persons
was that the decision? Was that the reason why? Was that the reason the Supreme Court gave in going by the issue in denying the issue of representation of the people?
Was that what?
Was that what the Supreme Court relied on
for this one?
No. In the Judicial matter,
yes.
Did the Supreme Court say that because he was injuncted before he was even
sworn
in?
Yes. Because we must. How is it that?
That's the decision.
Yes. You see, how is it that a court has granted an injunction, you disobey it, and then you come to a higher court? The whole substance of it from then on was that having been, I think there was a contempt of.
No, I'm not asking about your opinion. I'm not asking about your opinion. I'm asking whether this is what the judges stated.
Andy, before even you make the substance of my presentation, which is not, okay. I'm saying that judicial questions issue cannot be transposed.
Okay, so please move on.
Cannot.
So please move on.
Again, the Speaker, in assuming the powers of the High Court, made declarations which he does not have. An argument is being made that was service done or not. I don't buy that argument as well, because service is by Order 7 of CI 47. We all know. So the Speaker cannot...
Irrespective of if the CJ has given specific...
Yes, I'm coming there. Because, you see, if Order 47 has to be amended, it has to go through the Rules of Court Committee by a CI.
Are you suggesting that the CJ is not empowered to give administrative directives on
She is empowered to give administrative directives. Where it conflicts with a CI, the CI has sway. So, you cannot say that until they go through rules of court amending the provisions of service, Parliament should only be served on Monday, and therefore you will not accept service.
And the CJ,
that argument,
the CJ didn't know this when she was giving the practice directive.
There are several practice directions that aids us. Okay, I am saying that if it conflicts with a provision of a CI, the amendment of that CI must be through the Rules of Court Committee to amend that. Because there's a conflict. Otherwise, that is the law.